securities fraud, a financial crisis, blue sky laws. All of these concepts wrapped up in a motion for summary judgment. This is the Tutor Perini Corp versus Bank of America Securities, LLC case, a United States Court of Appeals for the First Circuit 2016 case that we are going to jump right into. So let's talk a little bit about the background here. We have the tail of the tape. You have to put this into context. The context is this is the late 2000s, right? We have a financial system that is near meltdown. Some big banks are folding up shop. We've got the securities market that is being attacked from different angles. We got mortgage crisis. We've got all different sorts of things going on. And we have this company who is this giant construction company, Tutor Perini. And with Tutor Perini, you have to understand that in this sort of market that they find themselves in, construction companies are feeling the pinch too. So they are looking for, as an investor with spare cash, the types of investments that they are looking for are low risk, short term, highly liquid investments because they need to fund their operation. They don't know what tomorrow is going to bring. They need to cover payroll. They probably need to have money on hand for certain bids and certain subcontractors in order to remain competitive. So Tutor Perini is highly cash conscious and risk averse. They are willing to kind of dip their toes in the water of investments with spare cash on hand, but they don't want to get their money tied up and not have access to it. Bank of America Securities, this is BAS. You'll see this abbreviation throughout the rest of the slideshow here, but BAS is a broker-dealer for Tutor. And during this time, we'll see that this case kind of revolves around how BAS is selling auction rate securities, ARS, auction rate securities to Tutor. Now, something to keep in mind is Bank of America Securities is a subsidiary of Bank of America, and you're going to see here how the court kind of distinguishes the two. But keep that in mind. We have BAS as one of the defendants. We have Bank of America, BANA, as one of the defendants, and Tutor Perini as the plaintiff. All right, history. This is like location. So in the mid-1990s, we are going to kind of get some of the framework and history of these parties. Tutor Perini gets into financial trouble. And when they get into this financial trouble, a lot of times banks will try to work out the financial trouble rather than maybe there is a balloon that comes due or some sort of note or business gets behind on payments. At that point in time, a bank has two choices. They could either try to file a lawsuit and maybe start to foreclose on certain properties or start going after personal guarantees on certain loans. But banks also try to do this workout plan. And the workout plan is, hey, we don't want to go through this whole process and try to squeeze blood from a grape. So instead, we want to try to work things out with you. Maybe we'll take some lower payments initially for a period of time to let you get back on your feet. And then we will wrap in some of the interest that accrues on the back end of a note. So here, this workout period is a time when a debtor and a creditor kind of hammer out this agreement and terms to reduce a debt or discharge a debt in order to just, maybe avoid bankruptcy on behalf of the company. And if a company files for bankruptcy, then the bank is going to be out of luck, depending on what sort of bankruptcy is filed. So, BAS here is a registered broker or dealer with the SEC, and they serve as Tutor's banking advisor under a revolving credit agreement during this workout period. Now, this credit agreement is important because the credit agreement had a certain limitation, and it had a limitation on what sort of investments Tutor Perini could get involved with, because the bank didn't want Tutor Perini to get into too risky of investments either. The whole point of the workout plan is to help steadily get Tutor Perini back on its feet here in the 1990s. So one of the specific limitations in this workout plan was that Tutor cannot invest in these auction securities, ARS, and keep that in mind here. So, what is an ARS? An ARS is an auction rate security. These are long-term investments, and they're backed by a variety of assets or revenue sources. So, here, some of the examples of auction rate securities were, student loans, municipal assets, mortgage-backed. And, we would have, at times, through perhaps some student loans, we would have a federal family education loan program. And this is, these are high-quality situations where maybe there's backing by an insurance company, or maybe even the federal government backs them. So, at times, these could be pretty quality investments, but there's other types of ARSs, and these are non-federal family education loan programs that deal with like student and municipal loans. So there are and there aren't, and the ones that aren't, the credit quality of these ones that aren't backed in this sort of way, the quality of them are a little fuzzier. Now, with some of the terminology we have this idea of a wrap. So in these non-FFELP student and municipal ARSs, we have insurance companies that are agreeing to make the interest and principal payments if a borrower defaults. You could see, that's a little bit riskier than if the federal government is backing the student loan themselves. Now, when you buy and sell ARSs at auctions, there are non-public auctions, so you must have a broker-dealer as kind of your agent. And this becomes important when we're talking later about what is Tutor's reliance on BAS. So keep that in mind, that these are non-public auctions, and you must have a broker-dealer kind of acting as your agent, advising you and kind of working the process for you. Now, a clearing rate is the lowest interest rate needed to sell off all available ARSs. So think about this in these terms here. We have max rate, and we look at how a successful auction works. Think about this terminology and think about it in the concept of an auction. So the clearing rate is the lowest interest rate needed to sell off all available securities. The max rate is the highest possible clearing rate. It's a cap. Now, if you could find enough buyers and enough bids below the max, that cap, to sell off all ARSs at the auction, then that auction is a success. But if not, then that auction fails. And when the auction fails, whoever is holding those ARSs, those auction rate securities, now they have to continue to hold them because the auction failed. It's not a good auction. So when they continue to hold them, now they have to wait till the next auction in order to try again. And those auctions only happen every 7, 28, or 35 days. You could see how this kind of sets the stage for a storm cloud starting to come at Tutor Perini. Before we even get into some of the details here, you could see that if Tutor Perini gets involved in ARSs, these are long-term investments, and not only are they long-term investments, but they may not be highly liquid, because if an auction fails, now I have to hold on to this. I can't get back my money right away. It's not as simple as going to a stock market and selling off your stock, or going to the bank and pulling some money out of your account. Now you have to wait. So this is the beginning of a storm cloud. Now, BAS and ARS. How does this all kind of come together? Well, BAS, as this broker-dealer, is playing all sides of these auctions. They are structuring and underwriting the ARSs on behalf of the issuers. They're soliciting and placing orders for investors who are also their customers. They're preventing auction failures by, and this is kind of interesting, because what they would do is, if it seemed like the auction was about to fail, BAS would step in and they would bid the rest of the bid in order to make sure that the auction did not fail. But then when they did that, now they gain ARSs within their own inventory. But now they have their own private inventory of ARSs. They don't want to hold on to these things either. So now they turn around and they start selling their inventory to their own customers. And you see how this circle just kind of keeps on going, because you have BAS who's playing every angle of this auction situation. They are handling things for the issuers, they're advising their investor customers, and they're making sure that the auctions aren't failing by submitting their own money and then turning around and selling those that inventory. You could see how this ARS market is not very transparent, because all of this is getting cycled through the broker-dealer. Is an auction successful because the market is good for it? Or is the auction just successful because the broker-dealer is putting in their own money behind the scenes and then turning around and selling that inventory outside of the auction? This is part of the argument for Tutor Perini. There's no way for me to know what am I investing in here. Is it a good investment? Is it a bad? Am I going to be able to get my money out at this auction or not? Are you, BAS, are you going to back this auction, or are you going to let the auction fail? All right, let's see how this downward slide starts to happen here. So BAS starts to push ARS, these auction securities, on Tutor. But it's kind of a series of events. So let's start in 2004. Tutor opens a non-discretionary investment account with BAS. Now, what this means is that BAS must get Tutor's authorization before making any transactions. So BAS can't just start investing Tutor's money the way it wants to, but it needs Tutor's authorization. Susan Mellis is the point of contact for Tutor. Now, BAS sends Mellis a recommended list to choose from. And you can kind of see when your broker, when your expert advisor is sending you a list, I don't know how often many people go beyond that list, but this is kind of how the stage starts to get set. Now, when this is going on, BAS is fully aware of Tutor's investment strategy. Remember, short-term, safe, highly liquid, We don't want to have our money tied up. And even within the credit agreement between BAS and Tutor, remember that credit agreement banned these auction securities from being a type of investment that Tutor can get involved in. Well, in 2006, BAS and their kind of point of contact at this point is a person named McGrath. She pitches ARS to Tutor, to Susan Mellis. And what she says is, in this PowerPoint, we are going to tailor our investment strategy to meet your needs. We're clearly defining the risk and reward of particular securities. And these are quotes from this PowerPoint presentation. We evaluate market conditions and determine which investment would meet Tutor's investment objectives. Now, as far as ARS is concerned, now they're saying ARS is a valuable investment tool. The ARS auction process has developed into an established and mature market. It is low risk and high liquidity. And, by the way, an ARS auction could fail and you will be unable to sell your security. So that's kind of like the small print. You have all of these fireworks going off in this PowerPoint presentation. Look, we know what you need. We are the experts. We're one with you. Oh, but by the way, ARS auctions could fail. And when they fail, you're not going to be able to get your money back. But everything is great. These things are safe. It's a mature market. It's established. And we are your go-to people for your investments. Well, at the end of this PowerPoint presentation, Tutor doesn't buy in. They don't buy in. But BAS is persistent. So in December 2006, McGrath says, we need to change your credit agreement because that seems to be a stumbling block. You didn't go with us the last time after my great PowerPoint presentation because your credit agreement barred this kind of investment. So instead, what we'll do is we'll just change your credit agreement. It's not that the strategy changed. It's not that Tutor wanted to get into long-term, high-risk, auctions. It was, hey, we'll change your credit agreement. And that's what they did in January 2007. Now, in summer of 2007, you can see, by the time January of 2007 comes around and they change the credit agreement, summer of 2007, the ARS market is in shambles. By that time, 60 auctions fail. There's this global credit crunch. The subprime mortgage lenders and insurers, they are running for the hills. And what people are talking about is this idea of a contagion. That if this could happen in the mortgage-backed ARS field, if all of these auctions can fail in that regard, well, it could be contagious. And it could bleed down to the student loan auctions as well. And this word contagion starts getting thrown around. But does that stop BAS? No. BAS floors the pedal. They don't take their foot off the gas and hit the brake. They floor the gas pedal. Internally, BAS, and this is at the summer of 2007, internally, BAS they're seeing the signs. And they are saying within their own private conversations, hey, we can't be a hero here. This is a really tough environment, and we need to make decisions based on our own interests. We may need to bid at our auctions to stop them from failing. And again, even BAS is throwing around this word contagion. They're worried that the mortgage failures in the auction field are going to spread to their field, the student loan auctions. And they're saying, well, what can we do to protect our portfolio? What can we do to reduce our inventory of ARSs that we have? And how can we start passing some of this on to some of our customers? Now, remarkably, at the same time that this internal conversation is being held by BAS, they're also going to Tutor, and they're saying, hey, Tutor, it's a good time to buy ARS. And Tutor responds back and says, well, are these actually better than our other investments? Oh, yes, they are. What about all these auction failures that are kind of going on? Oh, don't worry. Those are mortgage problems. That's not where you'll be. We'll be in the student loan area. Besides, we back the auctions you're involved in. The auction won't fail. So if you get involved in this sort of ARS student loan auctions, we'll back them. You'll be able to get your money out. But oh, by the way, small print, auctions may fail and you may not be able to get your money out. So at the same time, you're saying one thing with the right hand, you're taking it away with the left hand. But it must have been a good sell job, because Tutor signs off on getting into the ARS market. But what they do is they provide a limitation, and they say, well, we only still want AA or AAA credit ranked ARS investments. So they're still worried about having a safe investment, but with the promise that BAS is going to actually back the auctions that they are involved in, they kind of see, well, maybe this still could be a short-term investment, even though it generally looks like a long-term one. Now, the small or not so small print is, after each sale of ARS to Tutor, BAS would send a disclosure. And that disclosure is, we routinely bid in auctions to stop failure, but we are not obligated to do so. There's also this concept in this field of headroom. And headroom is, if you think about it, kind of like a margin. It's the space between the max rates and the rates demanded by buyers. And during this time, this headroom starts to shrink dramatically. And that is because there's broad concern over the credit worthiness of companies that are insuring the ARSs. So the auctions start to get a lot tighter, and there's this broad concern that some auctions are going to start failing. Now, in October 2007, BAS is still concerned about the headroom, about the auction success, about the way the market is starting to appear, even in the student loan area. In fact, the Wall Street Journal writes an article, and they kind of go through, and in those 60 failed auctions, those auctions were $6 billion. And it was because they couldn't attract enough buyers to have a successful auction. So this is all kind of swirling around this investment strategy that BAS has for Tutor. Now, does that stop BAS? No. BAS is not only persistent, they are relentless. So in 2007, as the Wall Street Journal is writing this article, as they're having these internal conversations, as they're doing research on the max rates, they call up Tutor. Hey, Tutor, you want to buy more of our ARS inventory? So Tutor buys more. They're still kind of hook, line, and sinker with BAS saying, okay, well, if you're recommending this, we'll buy some more. Now, not even a month later, in November 2007, there's a BAS memo that quite a few student loan ARS markets have come close to failing. But BAS doesn't advise Tutor of this. Instead, what BAS does is, hey, Tutor, you want to buy more ARS? You want to get into this a little bit deeper? We'll sell you some at a discount from our inventory. In December of 2007, the ARS market is one step from illiquidity. Now, remember, Tutor started out on this journey saying they wanted to be in safe, short-term, highly liquid investments. And here you got BAS, who every time they turn around is throwing ARS at them, even now when it's one step from illiquidity. BAS, for these auctions, they are submitting support bids. And these support bids are what we mentioned earlier with, it looks like the auction's going to fail. I have to step in, give a support bid so the auction doesn't fail, so people don't panic. And all of a sudden now, by me doing that, I'm getting huge amounts of ARS inventory. So BAS now is worried because now they're holding all of this ARS inventory and the house of cards is starting to shake here. So BAS risk manager says, what are we doing? We got to get rid of some of this ARS. This thing is starting to squeeze us. We're starting to suffocate on ARS. Within BAS, employees are starting to really get concerned. And they're getting concerned about their clients and recommending ARS to their clients. But no one tells. No one says anything. No one goes to Tutor and says, hey, we got to figure out a way for you to get out of this or stop buying into this. No one tells Tutor. In fact, it gets worse. BAS goes into self-preservation. In December of 2007, within BAS internally, they are saying we need to leave no stone unturned to protect ourselves. Should they let the auctions fail? Remember, if they don't come in, if they don't step in with a support bid, many of these auctions would have failed already. So now they are in a catch-22. If they let the auction fail, the ARS market in the student loan sector goes kaput. If they step in and they issue a support bid, now they just get more inventory of ARS. And at what point are they just going to say, we can't keep sustaining this? So what they do is they figure out a way to sell more inventory to investors like Tutor to improve their situation. But BAS never informs Tutor that there are issues with the max rates, that support bids have been going on, that there's record-setting levels of ARS and BAS's inventory, that there's these waivers that have been sought, that there's dwindling investor demand or internal discussions to let auctions fail. Because remember, BAS originally told Tutor that they would not let Tutor's auctions fail. But meanwhile, behind the scenes, they're talking about letting these auctions fail. And all the while, what they're saying to Tutor is, hey, you want to buy some more? By the end of 2007, Tutor had $196 million invested in ARS thanks to BAS. And in the end of 2007, Tutor gets out. They sell out all of their ARS shares. But it's not because they knew that all of this was going on. They just wanted to kind of be done with ARS. But we have a new year and the same script by BAS. In January of 2008, BAS, after Tutor had gotten out, they had sold all their ARS. Now BAS comes to Tutor again and says, hey, you want to buy some of our ARS inventory? And what they do is, in the prospectuses that they send out regarding the ARS inventory, they're saying, some of these small boilerplate warnings. The problem is that, once the house of cards starts to shake, it's hard to get it to stop shaking without the house falling. And that's what happens here. The market goes from bad to worse. In fact, the broker-dealer inventory increased because of support bids. Max rates narrowed. That headroom that we talked about, that margin, became minimal. And suddenly, student loan auctions began failing all over the place. But BAS doesn't tell Tutor this. Worse than that. Again, worse than that. They sell $30 million of ARS the very day that a AAA student loan auction fails. They sell it to Tutor. In February of 2008, you have big dogs like Goldman Sachs, and JP Morgan. They let their ARS student loan auctions fail. And that's on February 7th and February 8th. Meanwhile, BAS on February 8th and 11th, they sell more ARS to Tutor. On February 11th, the Wall Street Journal writes another article about the collapse. And even though BAS is aware of this article, they wait to tell Tutor about the article. And when they do tell Tutor, they say, don't worry, this is a bump in the road. We're still going to support your auctions. It's all going to be okay. February 13th, though, just 2 days later, BAS changes its mind. It decides that it's only going to support high max rate auctions. And it's going to leave Tutor holding illiquid investments now that it can't get rid of, which is not what Tutor ever wanted to be in the first place. I think your case says this becomes the worst case scenario for Tutor. And now we finally have the facts set up and we're able to get to federal court. So, federal question, 28 U.S.C. Section 1331. What we have here is we have different causes of action. We have federal securities fraud that Tutor brings against BAS and BANA, state securities fraud, state deceptive business practices, and common law misrepresentation. Now, both sides submit motions for summary judgment. And at the district court level, we have Tutor's motion for summary judgment being denied. So Tutor loses. We have BAS and BANA, their motions for summary judgment are granted. So when Tutor appeals, Tutor is saying, what the heck is going on here? Look at these facts that we just laid out here, and we lose on summary judgment. Meanwhile, these other two, they win, so we get nothing. So they appeal. And that brings us to our case here and the standard of review for our case. Now, the standard of review in a summary judgment case is de novo. That means from the new. So the appellate court is going to look at all of the evidence and not give any inference based on what the district court in this case ruled on. The appellate court will view all facts and drawing all reasonable inferences in the light most favorable to Tutor. And Tutor, because Tutor was the summary judgment loser. So when you have, in summary judgment, there were competing motions for summary judgment. What is being appealed here is the district court's ruling that granted summary judgment for BAS and BANA. Now, the standard always in a motion for summary judgment is there a genuine issue of material fact that would stop a court from entering judgment as a matter of law? So that is what we're dealing with here. Just like other cases you've seen with summary judgment, you always kind of go back to this standard. Is there a genuine issue of material fact? And in this scenario, are BAS and BANA entitled to judgment as a matter of law? Now, what does genuine mean? What does it mean when we say genuine issue? Well, that is, can a sensible jury decide the point in Tutor's favor? And the point is, a genuine issue is one that it's not something that's so inconsequential that it's not going to make a difference in the case. But can a sensible jury decide this point in Tutor's favor? And if they can, then we have a genuine issue and we have a material fact. The material fact is, again, this is a fact that is going to be outcome determinative of the case under applicable law. Now, with cross motions for summary judgment, the court has to kind of consider each motion in turn. When the court, let's say that here Tutor was also appealing that their motion for summary judgment was denied. Now, when the court is considering that, since Tutor was the moving party in that scenario, the court has to kind of flip-flop and draw inferences in different ways based on who the moving party was for the actual motion for summary judgment. Now, part of being de novo is a reviewing court can use any grounds supported by the record. So if the appellate court finds something in the record that even the district court did not review or did not consider, the appellate court here can use those grounds even if it wasn't relied on by the district court judge. All right, let's talk about issue number one in the case. Issue number one deals with, not BAS, but BANA. And BANA here, Bank of America NA, is saying, Tutor has failed to identify any misconduct we did. Let us out. You remember, BANA is just, BAS is the wholly owned subsidiary of BANA. So here, even when we went through the facts, there was nothing that I really mentioned about BANA. But Tutor says, not so fast. BANA was the controlling person and made some decisions regarding which auctions should fail. And BANA says, well, you never pled any of that in the federal or state control, in the underlying case. You never pled that federal and state controlling person claims were made. And you can't raise them for the first time in a motion for summary judgment. The court says BANA is right. The court says, sorry, Tutor, you never pled any facts in regards to this now. And it's too late. You can't raise it now because you waived it. We are dealing with issues that are in the record, not out of the record. So the court says summary judgment for BANA was proper, and BANA should be out of the case completely. Now, issue number two, state fraud. So in Massachusetts, which is where this case originates from, there is this idea of a blue sky law. All right, so with blue sky laws in Massachusetts, remember, this is a Massachusetts state law. So these were created to initially go after swindlers. They targeted swindlers because swindlers were so brazen and shameless that even the court here says, these people would try to sell a piece of sky to the wrong investors. So these blue sky laws created a strong incentive for security sellers to fully disclose all material facts about a security. But let's look at the actual language of the law itself. Here what we have is any person who offers or sells a security by means of any untrue statement of a material fact or any omission to state a material fact is liable to the person buying security from him. Let's break this down. So 1, if you have a defendant who offers or sells securities in this Bay State, this is a Massachusetts state law, by A, making an untrue statement of material fact, or B, omitting a material fact that the plaintiff A did not know was false or did not know was omitted, and that the defendant knew or should have known was untrue or misleading. That is kind of breaking down our blue sky law. But it's important to realize within that law what the plaintiff does not need to show. The plaintiff doesn't need to show reasonable reliance on its part or a bad mind, scienter, on the seller's part. In addition, the plaintiff's sophistication is irrelevant. So it doesn't matter if Tutor Perini is this, Goliath of the construction world and has an investment person on their staff. It doesn't matter. Reasonable reliance, proving a bad mind, the sophistication of the plaintiff, not parts of the blue sky law. The plaintiff also has no duty to check the accuracy of the defendant's statements. Here, the investment company, broker, they are the ones making the statements. So I shouldn't have to double check your work if you're coming to me as the expert. Ignorance of the untruth or omission is enough. I didn't know. I just didn't know. Now, the district court and the parties are fighting over whether an untrue statement or omission of material fact occurred in this case. Tutor is going to lose right off the bat in this court on the issue of an untrue statement because Tutor didn't point out a specific untrue statement in the response to the motion for summary judgment. So the court, it's an interesting little quote here. Judges are not like pigs hunting for truffles buried in the record. So the court is saying, we're not going to do the work for you. If you want us to consider something, you need to provide us with the evidence, with the citations, with the quotations, but we're not going to be like pigs hunting for truffles in the record to prove your case for you. Now, when it comes to the omission theme, however, the court is saying, boy, Tutor's entire response to the motion for summary judgment is based on this omission theme. You didn't tell us this. 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 You knew that the sky was falling and you didn't tell us this. So this is going to be the issue that we turn to now in this case. Omissions. What are omissions? Well, omissions at their very heart, at their very core, are failures to speak. And it's a little bit more than that. It's not speaking when you have a duty to speak. Or you speak misleading half-truths. So you offer a little nugget of truth to get somebody to buy off on it, but then you omit the unfavorable information. It's kind of like fishing. You throw bait out there, and you want the fish to bite on the bait, but you don't tell them that right in the middle of the bait is a hook that's going to bring them in. So, omissions. Tutor says, BAS made specific investment recommendations to us. They made all of these statements that we will define the risk and reward. We have your best interest at heart. We know what you're trying to do. And, BAS could only suggest us security. And what they said was, after studying it sufficiently to become informed as to its nature, price, and prognosis. And they were obligated to inform us of the risks involved based on these duties that they took upon themselves. The court says, on this, these seem like trial-worthy issues, that summary judgment is not proper, that these are issues for a jury to decide whether or not these are genuine issues of material fact. A reasonable jury could find that Tutor bought ARS based on BAS's omissions. If BAS would have told Tutor about some of these things, about how the ARS market was collapsing, then Tutor wouldn't have bought ARS. Tutor specifically said, are there better investments out there? Oh no, this is a good time to invest. There are no better ones. They never changed any kind of any representation that, even if it was accurate to start and became inaccurate, BAS never updated that inaccurate recommendation. Well, BAS responds, just because we didn't disclose one fact does not mean we have to disclose them all. Rather, just because we disclose one fact, just because we tell you something, doesn't mean we have to give you the full picture. That's BAS's argument. And the court says, well, that's true, but what about revealing the ones that are needed not to mislead? It's the same thing with fishing. You throw the bait out there, you got the hook in the middle, and BAS is saying, well, we just told them that we're putting bait in the water. That we don't have to tell them about the hook. And the court is saying, well, then you're misleading them. By omission, you're misleading them. Because they would never bite the bait if they knew the hook was in the middle. A reasonable jury could find you had information, but you were so desperate to sell for yourself that you did not give Tutor information that you had. So then BAS responds and says, oh, but this crash, it was so sudden. We were all taken aback. We were all taken by surprise. We were all trying to weather the storm. And the court says, well, this evidence really kind of cuts against you. You were talking about a contagion. You were talking about how this market was one step away from illiquidity. And yet, you kept going back to Tutor and saying, buy more, buy more, buy more. Oh, it's a good time. Buy more, buy more. We could go on and on. But this is not the stuff for a motion for summary judgment. These are genuine issues of material fact that a juror and a jury should decide. BAS then says, well, Tutor should have done its own research. And news outlets, they reported stuff like this. You got all these Washington Journal. Why didn't they read the paper? If only they would read the paper, we wouldn't be in this position. The court said, well, that's not the nature of a blue sky law in Massachusetts. Remember, we don't have to have reasonable reliance, or we don't have to look behind the scenes of the recommendations that you are giving to me. I could trust what you're saying, and I shouldn't have to verify your recommendations. BAS won't stop there, though. BAS says, Tutor knew if an auction failed, they weren't going to get their money back. They knew before they ever bought that the possibility of an auction failure was possible. But here the court says, yes, that's true, but when they asked you about the student loan market, you told them a couple of things. You would back the auction, and that the problems with failures were coming in the mortgage realm, not in the student loan realm. At the very least, again, this is a question for a jury to decide. It's not proper for a motion for summary judgment. So BAS says, well, here's what Tutor had access to show that we didn't omit certain information. They had information regarding the max rates. We put those in the prospectuses. The court said, these say zip about what was actually happening in the market. They're hard to understand. They're outdated. This isn't on-the-spot information that you could have given to Tutor. the ways to calculate the ARS inventory that you held at any time, BAS says, oh, we gave them ways to calculate our inventory. And the court says, no, again, you sent outdated, inaccurate, incomplete information. And again, these are issues of material fact. They're not proper for motions for summary judgment. BAS, I'll tell you, as persistent as they were in trying to sell Tutor the ARSs, here they're just as persistent in trying to come up with reasons why they didn't omit information. So now they use this Hill case, and we get into this idea of a Grand Canyon situation. So BAS cites this quote from the Hill case. And it basically is that if a defendant discloses a risk, you don't have to give the precise degree of risk. If that is what the plaintiff's claim is based on, it's not sufficient to render the statements misleading just because you don't with absolute certainty define the risk. But what the court says to this is, you wave this around like it's a trump card. But the rest of the case says, a statement of risk does not insulate the speaker from liability if it's generic and formulaic. In addition, a level of risk can be so understated that it is misleading. Here, there was disaster looming on the horizon, and you whitewashed it. We have to take this whole situation in a light most favorable to Tutor. What we see from that is that this is a situation where you pushed ARS, that ARS was one step away from illiquidity, that this whole market teetered on the brink of collapse, and you still pushed ARS. We see that a reasonable jury could find that in this Grand Canyon situation, you whitewashed it so much that you urged Tutor to walk right off the cliff. BAS against responds, and they bring up this Bachman case. And Bachman, it is a Polaroid case that disclosed that it was selling these Polavision cameras below cost. But they didn't exactly define what the cost was. And the court there said that it wasn't a misrepresentation because it didn't specifically define what below cost meant. The court says, yes, but if the management knew that there was a commercial failure, simply saying that earnings were negative, that might well be a material misrepresentation by half-truth. So even in Polaroid, where, again, BAS is bringing up this case to say, we disclosed enough. We might not have disclosed everything, but it wasn't a misrepresentation because we did enough. Here, the court again responds back and says, no, you didn't go far enough. You knew about the impending disaster, or a logical jury can deduce that. And you were hoping to escape liability through these boilerplate disclosures that did not jibe with current market conditions. Now BAS tries another Hail Mary, and they say the blue sky law in Massachusetts only applies to public, not private offerings. And they say, we look to the federal statute because the prospectuses only deals with public, and this is a term of art. And the court says, no, we're going to look at the Uniform Blue Sky Act, which the Massachusetts Act is based on. And in that Uniform Act, it applies whether the sale of these securities are public or private, primary or secondary. So while we look to a federal statute, and that might be proper in some situations, the state statute does not have the same limiting language that the federal statute has in this case. So the court kind of dismisses that pretty quickly. All right, issue number 2. Here, what we have is because the state securities fraud claim turns on the same fact questions, the matter is not so one-sided that one party must prevail as a matter of law. Tutor is entitled to a jury's decision on this claim as well. All right, let's talk about the federal securities fraud cause of action. Here, with omissions, we have kind of a little bit of a tweak with what an omission is under the federal statute. So here we have a material omission, the wrongful state of mind, scienter, connection with the purchase or sale of a security, reliance, economic loss, and causation. Court says here the parties are fighting over number 1, the material omission again, and number 4, whether the reliance was reasonable. On number 1, the district court judge said there can be no omission when BAS disclosed the risks in their documents. So the district court judge bought off hook, line, and sinker on the disclosures that were made and that boilerplate language that BAS was given to Tutor. The district court judge said there could be no reliance when risk of failure was adequately and accurately disclosed. So that is why the district court judge ruled for BAS on the motion for summary judgment. Now, what about here? The court here says, we're still not persuaded by BAS's argument that it discloses a morsel and has no further duty to update anything. Here, what the court says is reliance is generally a jury issue. It's generally something that a jury should decide. So I don't know why the district court judge was making a determination on reliance. We are not going to change the law here to accommodate BAS. There's no reason to. So in this court's eyes, the appellate court's eyes, the federal fraud claim survives the motion for summary judgment. But there is an unsuitability claim as well. And that unsuitability claim requires that a plaintiff show that the defendant is responsible for some misrepresentation or material omission. And here the court says, Tutor, you had a non-discretionary account. This was investor directed. You were driving the train. You were making the decisions to invest or not invest. And you have not cited any authority for us to show us that with a non-discretionary account scenario that you can bring an unsuitability claim. And again here, this court's little pet peeve is we don't do your work for you. And that's a lot of courts' pet peeve actually, but they're just pointing it out here and saying, we're not going to search the record. We're not going to search case law to try to make your case for you. We gave you the opportunity to cite authority to us on this issue. You didn't do it. Too bad. Now, what about the state misrepresentation claim? With misrepresentation, there could be negligent and intentional misrepresentation. This falls under Massachusetts Chapter 93A. Any business entity injured by an unfair or deceptive act or practice by another business entity. Here, the district court, in this case, found that there was no material misrepresentation. So they granted summary judgment on this issue based on that alone. They never went any farther than that. They just said, no, we don't find that there was any material misrepresentation. Here, this court already found that there were material omissions or potentially material omissions that a jury should decide. So they said, the fact that the district court never made it any farther than this, we're already completely on the other end of the spectrum. The motion for summary judgment was not proper on behalf of BAS by the district court. So here, this issue is trial worthy. So in conclusion, here we have a scenario where the motion for summary judgment is vacated in part and survives in part. The state securities fraud claim, there's no motion for summary judgment. The court says that's got to go to trial. The federal securities fraud claim, no motion for summary judgment. Go to trial. The state negligent misrepresentation, no motion for summary judgment. It's got to go to trial. The state unfair business practices claim, no motion for summary judgment. But on that unsuitability claim, Tutor loses. And they can't bring that claim because they haven't cited any authority that in a non-discretionary account that they can bring an unsuitability claim and survive a motion for summary judgment. The court then gives a little olive branch to BAS and says, oh, by the way, you didn't, on the motion for summary judgment, you moved for summary judgment on other grounds that the district court never even considered. Those can still be argued when we send this case back down to the district court. Since the district court ruled so quickly that there was no misrepresentation, there was no omission, and that BAS should get summary judgment on those grounds, they never made it to other arguments that BAS made in their motion for summary judgment. The appellate court here said those are still valid arguments that need to be addressed down at the district court level. You could argue it there. We're not going to handle that here now. All right, that is our Tutor case. Pretty interesting stuff about federal securities fraud, about this ARS market, and a period of time where our country was struggling to find its footing in some of this financial world.